Hello and welcome to Connected with Latham, where we discuss ideas, legal developments and business trends shaping the global economy.
I'm Deborah Kirk, a partner based in London, and I'm joined by my fellow Latham colleague, Associate Elva Cullen. In this episode, we discuss one of the key topics of interest in our world at the moment as IP lawyers, the Copyright Directive, a hugely controversial piece of legislation that has finally been passed and is undergoing the implementation phase. This short session will be of most use to those businesses which handle large amounts of user-generated content and which operate in both the UK and Europe and possibly elsewhere. We are presuming a degree of knowledge of the Copyright Directive for this session and the wider EU's Digital Single Market Programme, although if there is any element of this legislation you want to discuss with us, we're easy to find, so please feel free to reach out. So after months and months of debate and with a backdrop of claims that it would break the internet and would bring memes to an end, the Copyright Directive was finally passed on the 7th of June 2019, allowing a 2-year implementation period which ends on the 7th of June 2021. So what does that mean for the UK?
Well, in short, Debs, it means that the UK will not be required to implement the Copyright Directive, and it will effectively be optional. So the implementation question has been the subject of commentary by members of Parliament, with 2 UK government ministers separately commenting on the UK's position on the Copyright Directive. Chris Skidmore, who's Minister for University Science, Research and Innovation, has said that the UK, and I quote, will not be required to implement the directive, and the government has no plans to do so. Any future changes to the UK copyright framework will be considered as part of the usual domestic policy process. But in Parliament, Nigel Adams, Minister for Sport, Media and Creative Industries, said that the government will support the overall aims of the Copyright Directive, even if the departure from the EU means that the UK is not required to implement it in full. So, somewhat of a mixed message from those 2 ministers.
Right, so perhaps it's not an outright no and never from the UK. Maybe what we're hearing is that the answer is not now, but the UK may consider implementation of some sections of the Copyright Directive at a later stage, perhaps?
That's right. It's not clear which view is the most accurate, but for now at least, we know that the Copyright Directive is not being implemented in the UK, given Brexit. Discussions in the House of Lords suggest that in future changes may be made to the English copyright legislation in order to reflect or perhaps mirror some of the Copyright Directive developments. Lord Callanan of the Conservative Party noted in March that the government would, and again I quote, see how it works and will continue to keep the matter under review. It is of course a matter for this Parliament to determine how our copyright protection framework goes forward.
I suppose in many ways this could be seen as a positive for the UK in that it can pick and choose which elements of the directive it sees as a positive addition to the legal framework in the UK and which elements it prefers to leave to one side. I suppose arguably it's an opportunity for the UK, right?
That's true.
But I guess equally we need to think about where that leaves businesses in the meantime, who as a result of this will be required to operate under 2 possibly conflicting regimes, given these businesses are often social media platforms operating across numerous jurisdictions.
Definitely. I think it's first just worth noting that the Copyright Directive is actually a core element of the Digital Single Market Initiative, and it's an additional and significant step closer to the Digital Single Market's aim of harmonising digital rights. And the UK's non-implementation of the Copyright Directive strikes quite a loud note of discord in that harmony. So one of the focuses for the Copyright Directive was the regulation of platforms with a broad user base and substantial user uploads, which are largely unchecked.
And as a result, these businesses are going to have to determine how they comply with the Copyright Directive and how to align that compliance with their obligations under national laws in the UK, which is surely going to cause confusion for rights holders, given that the Copyright Directive gives rise to new rights which won't then be available to creators in the UK. So, for example, the press publishers' rights or the link tax as it's become known under Articles 15 and 16, right?
That's really true. And the fact that the UK has already implemented and plans to implement other elements of EU legislation which play into the digital single market enhances the discord. So, for example, the e-commerce directive was implemented by the UK Electronic Commerce EC Directive Regulations 2002, and the Audiovisual Media Services Directive is going to be implemented later this summer.
Of course, the lack of harmony is particularly noteworthy between the Copyright Directive and the e-commerce directive as it applies to copyright. One of the most controversial provisions, as we know, in the Copyright Directive relates to the new obligations on online content sharing service providers, as they're called, or OCSSPs, regarding unauthorized use of protected content. And in order for them to comply with their copyright obligations, it looks as if OCSSPs will need to monitor the use of protected content, which jars pretty uncomfortably with the e-commerce directive provisions, doesn't it?
Yeah, it really does. One of the first issues is that information society service providers could lose their safe harbour protection under the e-commerce directive. So just to unpick this, where information society service providers take down unauthorised protected content as soon as they have actual knowledge of the content's illegality, the e-commerce directive offers them a safe harbour against direct liability. But in order for those service providers to comply with Article 17 of the Copyright Directive, they're likely to need to implement persistent monitoring of content. So in effect, they'll have constant actual knowledge and they'll be denied the benefit of the e-commerce directive safe harbour. Then another issue is that the concept of an online content sharing service provider is entirely new and not clearly defined. The e-commerce directive refers to information society service providers, and it's not obvious whether all OCSSPs will be considered to be information society service providers or vice versa. And so it's just not clear whether all platforms will need to comply with both directives.
Yeah, I see that. And also there's the fact that the application of the Copyright Directive is, as it suggests, limited to copyright, but the e-commerce directive applies more broadly, so it captures all IP rights, including copyrights, of course. So I guess unless platforms can devise a means of monitoring that identifies only copyright material, which is infringing, and on the face of it, that seems to be extremely technically challenging, unless they can do that, that they will be monitoring more broadly and therefore risk losing their safe harbour under the e-commerce directive, but not only in respect of copyright, but mainly across the board. I guess there's also a further misalignment between the Copyright Directive and Article 15 of the e-commerce directive, isn't there?
Yeah, and so this misalignment probably affects member states a bit more, but will obviously impinge on information society service providers too. So Article 15 prevents member states from imposing content monitoring obligations on information society service providers. But it seems that member states in implementing the Copyright Directive will, at least implicitly, impose such an obligation on OCSSPs.
So the mismatch between the e-commerce directive and the Copyright Directive is an issue in the context of the UK not implementing the Copyright Directive, but it will also affect the EU generally as we see member states start to implement Article 17 and as rights holders, OCSSPs and information society service providers start to question how it fits with their e-commerce directive rights and obligations, right?
Right. It's likely that within the EU, these conflicts between the Copyright Directive and the e-commerce directive will be clarified before too long, either through Commission guidance following the Article 17 stakeholder dialogues or possibly through a CJEU judgment. But within the UK, this conflict is likely to persist for a while. So OCSSPs who implement broad monitoring systems run the risk of losing their safe harbour protection under the UK Electronic Commerce Regulation and being found directly liable for unauthorised protected content uploaded by their users.
Yeah, it is difficult to see how the OCSFPs will be able to navigate between this risk and complying with their Article 17 obligations. The workarounds like geo-blocking or limiting website access would, for many of these providers, simply limit the functionality or appeal of their offering.
True. As we noted when the government first made its announcement of non-implementation, it's not only this tension between Article 17 and the e-commerce directive that's going to be an issue for OCSSPs.
Yeah, of course. We're focusing on the inconsistency arising from different regimes between the UK and the EU position, but if we take this legal question and put it back into its practical context, we should remember that the kind of service providers we're dealing with here, by the nature of their services, are online international businesses with international platforms and international users, and as such, the legal regimes which apply to these providers, they go beyond the EU, both as it was and will be. And I suppose these providers are already dealing with varying legislative regimes that make it challenging to take a broad brush approach with regards to compliance. Even amongst the laws of member states, there must be divergence.
Yes, so I think we can say that while the UK's decision not to implement the copyright directive will add an extra layer of complexity, it's not an entirely new problem for these entities. They will also be used to the concept of following the highest common denominator or gold standard regime in other areas, such as consumer laws and data protection compliance.
Yeah, that must be the case, although I suppose the difficulty here is that there are essentially two conflicting gold standards. Going back to the point of this isn't limited to a sort of EU-UK relationship, it's worth thinking about the position in the US, where under the US Digital Millennium Copyright Act, that legislation doesn't require monitoring, similar to the position under the e-commerce directive. And if providers were to implement monitoring as a result of the copyright directive, that may impact a platform's ability to rely on the safe harbors under the US legislation as well. So US and UK activity might need to be subject to different models versus the models in the EU. And there's, of course, a question as to, as we said, whether technically and practically that's possible without significantly impacting user experience, functionality, or in general, the benefits of a global offering. I suppose the starting point to an answer to any of these questions is going to have to lie in the development of guidance around the practical intentions of Article 17, and we'll need time, implementation legislation, and market practice to unfold before we get that guidance. And also, I suppose, while OCSSPs might explore a two-pronged approach, the varying regimes are likely to be pretty confusing for rights holders. I suppose particularly if they're individuals or small businesses, that they may well find it difficult to simply understand what rights apply to them. So, for example, infringements may arise in the EU now, but not in the UK as a result of the new legislation not being implemented. So take the new press publishers' rights, for example, which will now exist in the UK, but not the EU.
I suppose, on the other hand, there is a possibility that we could see more sophisticated right holders taking advantage of the diverging positions and seeking to litigate where it's most beneficial for them.
Yeah, that's true. There could be instances of rights holders relying on continental copyrights, let's say in France or Germany, which exist as a result of the implementation of the copyright directive, but then bringing that infringement claim in the English courts, given that, as far as I know, the case law still allows that, and that could lead to forum shopping opportunities by rights holders. So lots to think about. I suppose it would be a good point to think about what's next for the UK in relation to the copyright directive. What do you think, Elva?
I think we definitely need to watch this space. We know that the UK is not at this stage implementing the copyright directive. We also know that the copyright directive does not sit well with existing EU legislation, and that the inconsistencies between the copyright directive and English law are drawn sharply into focus by Brexit. It's likely to take the EU and the member states some time to clarify their interpretation of the copyright directive and then to align their approach. And it's possibly going to take even more time for the UK to then review, digest and implement the appropriate changes into national laws. So even though the UK will no longer have an obligation to follow decisions of the CJEU or EU guidance, it will need to carefully monitor EU developments. I think this will help to ensure that national copyright laws in the UK remain relevant and don't become a block or a deterrent to digital business.
Right, and looking at that sort of through a positive light, as we mentioned previously, the UK could use that opportunity to put itself in a sort of legislatively advantageous position, taking the positives and leaving behind what proved to be more problematic provisions?
Yeah, it certainly could. It could really just be an advantage for the UK, because the more the Copyright Directive is discussed and defined, the clearer its scope and to whom it applies will become. And the benefit for the UK is that it's going to be able to watch this process and ultimately pick and choose the best elements to implement into UK national laws.
Yeah, absolutely agreed. Well, thank you, Elva. Some really interesting points there to think about. We, the Latham IP team, will certainly be watching this space.
Thank you for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or anywhere else that you listen to your podcasts. And if you'd like more information about the topics in this podcast, please do email us using the links located in the show description. And we hope you will join us again next time. Thank you very much.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things, and you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 885 3rd Avenue, New York, New York, 10022-4834. Phone number 1-212-906-1200.